that when you file SLP, say you are filing SLP against an appeal under section 96 of CPC, which is first appeal before the High Court, or you are filing SLP against a judgment of acquittal. What I find is that when SLP is drafted, the lawyer doesn't go to the root of the matter. In fact, before he drafts SLP, he must study the matter, he must make research, and then he should be ready with the grounds which actually he is going to urge before the court. And if you do that, your drafting of SLP, especially the grounds which you take in the SLP and in the beginning of the synopsis, you put those arguments. Now, if you file mechanically, just pick up the appeal memo before the High Court and just copy it or add few normal grounds which you add, that will not work. Because see, as judge, if I have SLP which contains grounds, and I can, with our experience, we know that these grounds are only general grounds, or somebody has applied his mind and has formulated the grounds, the arguments which he is going to use in the court. If you incorporate those grounds, you have two advantages. One is that the judge who reads is in better position, and secondly, you will be in better position. When you argue your SLP position, everything is ready. In fact, I tell some of the young lawyers that if a case is covered by direct judgment, say of Constitution bench or any bench of this court, ideally you should be filing the copy of judgment, because it becomes very easy for the judges that a case is covered. We don't have to open our laptop or our iPad and make our own research and find out whether there is a direct judgment. So these are few things which you must keep it in mind, because ultimately, as I started with that ultimately your object is to see that your client gets relief. And if you want to be successful in that object, then it is obvious that you have to draft it properly. I'll use several examples. Now, for example, I saw some of the old question papers. There is one question paper which says that draft a delay condonation application. Thank you. Draft a delay condonation application where you have to explain delay of 300 days. I want to say something looking at the future. See, my generation of judges, I can say that we are very liberal when it comes to condonation of delay. Now, I remember when I started practicing in High Court, even today those grounds are in. What were the grounds available? That litigant was not aware that judgment has been pronounced. Litigant did not get copy of that judgment. The advocate engaged by the litigant had sent him a letter informing him that your case has been decided against you. I did not get the letter. These are the standard grounds. I am talking about private litigation. I will come to the applications filed by public authority later on. Now, with the passage of time, all these excuses are not going to be available. Judges of younger generation will throw out your application. He will say that, look, the moment judgment is signed, it is uploaded on the website. How can you say that you are not aware? The case status will indicate that case has been decided on a particular day. How can you say that you don't have copy? Because the copy is very much available on the website. Now, no lawyer is going to send you a letter now. No lawyer is going to send you a letter, because now even common man uses now cell phone. There will be either SMS, WhatsApp, whatever. That will be the mode of communication. Now, no new judge of new generation is going to accept such routine grounds. So therefore, now you'll have to be very meticulous. In fact, now I quite see a changing trend now. Keep aside criminal matters where accused has been convicted, where we are liberal, and we have to be liberal because ultimately Article 21 is involved. But in other cases, I see now the new generation of judges the new generation which is working in high courts, I see a complete change of approach. Now they are becoming very strict when it comes to condonation of delay. Because now with the advancement of science and technology, with better connectivity, now hardly any ground remains available. Now I remember in high court, somebody litigant in remote area, he used to say, sir, in the delay condonation application, that it was very difficult for me to travel from that particular village to the high court to meet the lawyer. Now all these grounds are not going to be available today. So therefore, as we progress, I am sure that the approach of the judges will undergo change when it comes to condonation of delay. Because as time changes, we have to change. One more thing. Now, even today, I met some young lawyers who are practicing here. They are AORs in one of the functions. Now, some of them said, sir, still there is digital divide, that we are not that techno savvy. We can't operate the equipment. Now, young lawyers who are going to be AORs of tomorrow, I want to make you one request, that you have to become techno savvy. There is no option but to adopt technology. And I also see that excuse, lawyers giving this excuse. I remember after the pandemic started in lockdown, right from day one, with my colleagues, I used to move from one district to other district in Karnataka. We used to visit some taluka places just to find out that how far video conference hearing is successful in trial courts. So I went to a trial court. It was a taluka court, and we had devised a practice. There, most of the courts are having huge compound. So because of the social distancing, we used to sit below a tree and arrange chairs. And I used to have discussion with the members of the bar. And of course, judicial officers used to be present. So in one particular taluka place I went, the lawyers started complaining, sir, there's digital divide. And we are not able to access. We are being denied access to justice. So I was just casually looking at the some young members of bar, who were members of the managing committee there. So one young lawyer was constantly looking at his cell phone. So I ultimately asked him, I said, Mister, I am not asking you which film you are seeing on your cell phone. Because everybody will feel awkward if I ask you that question and you answer that question. But now you are so techno savvy that you are using that gadget to see something, some YouTube or maybe any other media. So therefore now, as we progress now, tomorrow I think we are going to open a premises here where e-filing facilities will be available. So you have to get equipped with e-filing also.